Welcome to the show. Today I have the great privilege in speaking with Mr. Kent Roach, Professor of Law and Prichard Wilson Chair of Law and Public Policy at the University of Toronto Faculty of Law. Kent is a graduate of the University of Toronto and Yale and a former law clerk to Justice Bertha Wilson of the Supreme Court of Canada. Kent is the author of numerous books, many of which have won awards on issues and topics that include constitutional rights, matters of criminal law, and national security and terrorism. Kent is also the author of the Criminal Law and Charter volumes in Irwin Law's Essentials of Canadian Law series, which, in an aside, Kent assisted me greatly during much of my law school career and again now in making this podcast. Kent has also written over 250 articles and chapters that have been published in numerous countries around the globe. Kent's awards and recognitions are long and numerous, but include awards for teaching and writing, a 2015 appointment to the Order of Canada, and in 2016 being named one of the top 25 influential lawyers in Canada for the Changemaker category. Kent has also won numerous awards for his pro bono work, contributions towards civil liberties, representing Aboriginal and civil liberty groups before the courts on many high-profile and notable cases. Kent, I could go on, as your accomplishments are long and many, but thank you and welcome to the show. We really appreciate you coming on.
Well, thank you very much, Trevor. That's a very generous introduction.
Now, there are many things, Kent, that we could talk about, and I would love to get your insights on. But obviously, we're going to try to narrow the focus just due to time constraints. And for today's purposes, we are going to discuss juries. And the case we are following in our first season has had 2 jury trials. It has been appealed to the Supreme Court of Canada right now, or leave to appeal. And the Crown just recently came out and said that they won't be proceeding with a third trial if it doesn't work out at the Supreme Court of Canada. So we'll get into a little bit more about jury trials in general here in a minute. But in doing the research for juries and my conversations about juries, I think it's fair to say that the jury is regarded as a pillar in all Commonwealth justice systems, and it's often described as an important institution of a democratic and liberal justice system. Yet at the same time, I do see a lot of articles, usually backed by social science evidence, with some concerns of the jury system in terms of poor juror comprehension or potential biases and prejudices, and even the juror representation issue. So my first question, Ken, and it's just a general one, is are you someone who's a strong proponent of the jury system, or do you have any concerns with the jury system in today's modern system of law?
Yes, well, I mean that's a very good question, Trevor. I first really thought about the jury in a case not unlike, in some ways, the case that you're looking. When I was clerking with Justice Wilson, there was a case called R versus Turpin, and it involved a woman who was accused of having a contract hit on her husband. And she made an argument that eventually the Supreme Court rejected, that she should have a right to a non-jury trial. So this was a person who actually, for whatever reason, thought that a jury trial would not be in her advantage. And of course, I mean, I grew up, one of the formative events for me when I was a young law professor were the LA riots after the Simi Valley jury acquitted 4 police officers of beating Rodney King. So I think it's fair to say that I started my career with some skepticism about the jury. I've been involved with cases that established a precedent that you can ask prospective jurors about whether their racism against, in this case, an Indigenous accused, Victor Williams, would prevent them from deciding on the evidence. And I've also been involved with litigation over jury roles in Northern Ontario that underrepresented Indigenous people, and most recently, the very controversial repeal of peremptory challenges that were used in the Gerald Stanley Colton Bushy case. So I think it's fair to say that I'm skeptical of the jury. But having said that, I guess as you get older, you reevaluate. I mean, one of the things I really do appreciate about the jury, though, is that it is a kind of a counter-majoritarian institution in the sense that one person can hold up the jury. The jury has to, all 12 people have to agree for a verdict. And Canada has maintained that position. And I think that that is quite important. And then I guess the last thing I would say is, there's a lot of symbolic fights about whether you like the jury or not. I remember writing an op-ed in the Globe and Mail after the Rodney King case and getting a lot of angry mail. But the other thing I think Canadians should be aware is that most accused of more serious indictable offenses actually can choose whether they want a jury or not. And most of them, for whatever reason, choose not to have a jury. So the vast majority of cases outside of the murder context in Canada are decided by a judge alone. And in many of those cases, if the accused really wanted a jury trial, he or she could insist on it. So sometimes people vote with their feet.
Do you have any thoughts on why that might be?
Well, I think it is from the defense lawyer's perspective that they're more comfortable before a professional judge who has seen grisly photographs or allegations of wrongdoing. And they also know that the judge will have to give explanations for his or her decision, which can then be subject to appeal. The thing about the jury is we never really know why they decide whether the person is guilty or not guilty, because especially the criminal jury just really gives a 1 or 2 word answer to each allegation that is raised.
Right. And I planned on talking about this a little bit later, but I think this leads nicely into it in terms of the secrecy laws that Canada has in place, in terms that juries cannot discuss their deliberations. There's been some criticism of that because it's tough to know what went on in those deliberations, if there was any undue influence or any prejudices. Do you think Canada needs to look at those secrecy laws?
Yes, I do. I mean, there's been lots of recommendation that there should be at least the ability for academics to do research, but I think I would go farther and even move to something more like we see in the United States, where it's really up to the individual jurors whether they want to discuss. One of my concerns is that the Supreme Court has really valued jury secrecy and the privacy of the jury. I mean, it isn't an absolute rule. You can get into it when it comes to investigations of obstruction of justice if someone was messing with the jury, but that's really all that's available. And so I, tend to think that when power is exercised, reason is important. Now, obviously, I wouldn't go so far as to say juries should give reasons like trial judges do, but I'm not comfortable with them being silenced under threat of criminal sanction, which is the case now.
Right. And there are some people out there that think that juries should be required to give some sort of reasoning. You said you're not comfortable with that. Can you explain why?
Well, I mean, the civil jury sometimes is given a kind of structured verdict, and that might actually be a good idea because, I mean, the other thing, and you know this as a former lawyer, and I as I teach criminal law, I struggle with this every day, is our criminal law has become incredibly complex. And so the judge, when he or she explains the law to the jury, which then has to find the facts and apply it to the law, is really talking to two audiences. The judge is talking to the jury, but more importantly, the judge knows that whatever he or she says could be reviewed by the Court of Appeal and ultimately by the Supreme Court. And so one of the things that I fear is our jurors have the same glazed eyes that my students at the law school sometimes have when I'm discussing the precise difference between murder and manslaughter, or the complex test for self-defense or intoxication or provocation.
Right. And I guess that leads into a next question about more criticisms I've read about juries is that they're often involved in these very complex, the most complex cases. Usually it's built right into the charter right that it has to be 5 years or a punishment more severe, which brings up other interpretation issues. But generally, these are very complex cases, usually with a lot of different pieces of evidence and legal principles. And is that a concern for you in terms of juror comprehension?
Yeah, I mean, it certainly is a concern about juror comprehension now, but I also recognize that some other people would say, and, sometimes even myself would say, maybe the jury has an ability to cut through all the legalese and all the bump and do it on the basis of common sense. But my work with Indigenous and other racialized people and my study of wrongful convictions leads me to worry a little bit that if the jury is just basing it on their gut instinct and common sense, that many of us have implicit forms of bias. So, the jury that convicted Donald Marshall Jr., wrongfully convicted him, was obviously not very impressed with the way the 17-year-old Mi'kmaq man testified, but they got it wrong.
And certainly in the case that we're following, post-offense conduct and demeanor evidence was a big aspect of this case. Well, it was a purely circumstantial case. And I know there's some concern some of this evidence is maybe more apt to be used incorrectly by juries and lead to wrongful convictions. Do you have any thoughts on that?
Yeah, no, exactly. The judge can give an instruction, but, if I tell my students near the end of my lecture, don't think about what you're going to eat for lunch, I'm just virtually guaranteeing that they're going to think about what they're going to have for lunch. So I've always been skeptical of judicial warnings. And, I go back to that Turpin case that I talked at the beginning, is that I do think when there's post-offense conduct and things that look suspicious, I think that, many people think that judges who are kind of trained professionals might have a different view than someone who is, shocked at someone doing something that may look bad, but is not necessarily evidence that they've committed a crime.
So we'll turn now to the Charter generally and specifically Section 11. And just as a background for listeners, Section 11 of the Charter deals with the rights of a person involved in a criminal or penal proceedings. And Section 11F of the Charter provides any person charged with an offense the right to the benefit of a trial by jury where the maximum punishment is 5 years or more. Practically, Kent, can you explain what this looks like for an accused when they have to make this election, or how that election is done?
Yeah, I think I'll start with murder because that's the case that you're looking at. So, murder is a case where back in Donald Marshall's day and back in Turpin's day, there was no alternative. There was a mandatory jury trial because murder was seen, like treason, as so serious. Now, if you're charged with murder, there really has to be a jury trial unless both the accused doesn't want one and the Crown agrees. So the Crown has a veto, and there's some reported cases where Crowns agree, and also when Crowns disagree, and the court says that they should have allowed a non-jury trial. In terms of other cases, if you're charged with robbery or something like that, then it's really up to the accused to decide whether he or she wants a trial in front of a judge alone or a trial with a jury. And of course, in Canada, this is also about whether you're going to be tried in the provincial court or the superior court. And I think many defense lawyers are more comfortable in the provincial court, think that they can usually get a trial quicker, and if their client is found guilty, will probably get a lesser sentence. And of course, we have to realize that most criminal cases, people plead guilty. So, when I teach criminal law, I disproportionately teach murder cases. When people like you do podcasts and other cultural manifestations, we often focus on murder because it is the most serious crime. But in terms of the jury, it's a little bit of a distinct crime.
Right. And is it just murder, Kent, where the Crown holds this veto?
No, it's all of the offenses listed in Section 469 of the Criminal Code.
Okay.
I always chastise my students when we used to have classes if they didn't lug their criminal codes. So I've found it on my office floor where most of my stuff is. And I can tell you that the other offenses under Section 469 include intimidating Parliament, which is obviously something in the news, treason, inciting to mutiny, seditious offenses, piracy, and murder.
So those are kind of what our government has recognized to be the most serious of crimes in Canada.
Yeah, our government perhaps in 1892 when the criminal code was originally enacted.
Yes, right.
I'm not sure there's a lot of piracy, and thankfully not a lot of intimidating Parliament, although I hadn't thought about that offense. So you might have given me an idea for my criminal law exam.
Yes, some might be a little outdated there. So turning to 11F, and I do want to get into talking about the Turpin case more with you here, but 11F in general, I just want to get your thoughts on why they included the 5 years or more severe punishment. To me, it strikes me as a little bit odd. It almost seems like they're putting a procedural right into the Charter.
Yeah, I mean, I think it reflects the fact that we have the jury and we recognize it as part of our common law heritage, but also we're a bit ambivalent about the jury. And so the 5 years or more, actually in Australia and in the US, constitutional rights to a jury bite in much less serious cases. So I think the 5 year cutoff reflects this kind of ambivalence that the number of jury trials in Canada have never been as extensive as south of the border or in Australia.
Is it arbitrary, or do you think it's just they had to pick something?
Yeah, I mean, I do think in some ways it's arbitrary because, 5 years is not a kind of significant number in the criminal law. I mean, 2 years is a big number because if you're sentenced to 2 years, you go into the federal system. And if you're sentenced to less than 2 years, you go into the provincial system. So I'm actually not sure how they chose five, but it is quite arbitrary.
Yeah, and when I was trying to research 11F, I couldn't really find much in terms of any parliamentary record that really related to a Section 11F. So it is tough to try to figure out the intentions of the drafters, I guess. But turning now to, if we could just talk a little bit more about the Turpin case, because obviously you're quite familiar with that case, given your role at the time.
I mean, as I suggested at the start, Sharon Turpin's claim was Section 11F, although it guaranteed the right to a jury, should also guarantee the converse, the right to a non-jury. And the Supreme Court unanimously decided that Section 11F did not go that far. This was in 1989. The court was giving charter rights a very broad interpretation at the time. These were very early days in the charter, but the court didn't go too far. And I guess for me, it just kind of revealed, and this was kind of cemented when I started teaching the Donald Marshall Jr. wrongful conviction to my criminal law class the next year, that for some people, although Section 11F talks about the benefit of a trial by jury, some accused don't think it's a benefit. They think it's a burden. And Sharon Turpin thought it was a burden. And perhaps Donald Marshall Jr., who was tried in front of 12 white men and wrongfully convicted in Sydney, Nova Scotia, probably thought it was a burden too.
Generally, do you think 11F should encompass that right to not proceed with a jury?
Yeah, I mean, my own kind of personal opinion is it probably should, but that's not what the Supreme Court decided. And Justice Wilson was known as a judge who was not afraid of interpreting the charter in a broad and generous way. Most people probably remember her Morgenthaler decision and other decisions that she made. But I've always, frankly, personally, had some sympathy for the idea that if someone thinks they're going to get a fairer trial in front of a judge alone, we allow them to make that decision in almost every other case except murder. Why not allow them to make that decision in murder cases?
And from what I understand from reading the decision, it was essentially that, correct me if I'm wrong, but the accused can elect to have jury or no jury. But once they make that election, the Crown still has that veto that we discussed through the criminal code.
Yeah, I mean, that's generally right. I mean, as I said, I mean, I think the criminal code has been reformed since Turpin to at least allow for the possibility of a non-jury trial. So, I think that that's some improvement, but the Crown, as you said, still has a veto, really only in murder cases.
So the benefit of a trial by jury has been discussed a lot, and review of case law seems to take a kind of community standard, societal benefit approach to interpreting that phrase. But there are some that have argued that the benefit of a trial by jury must mean something more for the accused, because why would they proceed with the jury if they're going to get the same type of a result with the judge type of thing?
Yep.
And I've read a couple articles where the authors argue that the only logical interpretation would be to suggest that juries could be permitted to disregard the law or go against the evidence, also known as jury nullification. And I'm just wondering if you have any thoughts on whether you think 11F could be interpreted like that.
Yeah, no, I mean, that's an interesting question. Supreme Court, again, and I think this reflects our societal ambivalence about the jury, really has gone in different directions. So in a case called Krieger, the court has said, even in a case with overwhelming evidence, the judge, after the accused has elected trial by jury, can't take the case away from the jury. So it has to go to the jury. And I think in some ways, the only reasonable understanding of that is that there could be jury nullification. And of course, jury nullification really just means one of the 12 could disagree and stick to his or her guns. At the same time, the court has held that lawyers cannot urge the jury to nullify laws or not apply laws because they are unjust. So a defense lawyer cannot say that to the jury. So, as with so much with the jury, it's kind of a black box and a secret that, yes, there can be jury nullification. Certainly historically, jury nullification played a huge role in the Dr. Morgenthaler cases before the abortion law was struck down under the charter. So it exists, power exists, but we really are not allowed, or at least defense lawyers and judges are not allowed to tell the jury about that power. So the judge also would tell the jury, you have to accept the law as I say it is, and you're also not supposed to worry about the sentence. So another case I was involved with a long time ago for the Canadian Civil Liberties Association was the Robert Latimer case, where the jury was extremely upset when they found out that if you convict someone of murder, they're going to be subject to mandatory life imprisonment with a minimum 10 years without parole. And again, that, represents the fact that we kind of keep the jury in the dark, both about their power of nullification, but also about the consequences of finding a guilty verdict.
Right. And even in the Latimer case, the Supreme Court was very adamant that trial judges have a duty to guard against jury nullification. They described it as desirable and legitimate exercise for a trial judge. And it's my understanding that even in some trials, if you mention nullification or anything resembling nullification, it could result in a mistrial.
Yeah, no, and that's exactly right. And so, it kind of begs the mysterious question is, who is on the jury? And is there someone on the jury who, either by their own research beforehand or perhaps even during the trial, although they're not supposed to do that, or just their own knowledge or inclination is inclined to jury nullification. And of course, this is a real, this is one of the reasons why I think we're so anxious about jury selection, because once that person is one of the 12, then that can determine the fate of the trial.
And I guess for the jury system to work, it's premised on the basic principle that the jury is the one that has to decide whether the offense has been proven. But as we discussed, we don't know what their rationale is for that or those deliberations. For instance, in the Latimer case, it was very clear that it was a planned and deliberate death. And by the black letter of the law, first-degree murder, but the jury went on to convict him of second-degree murder. Is there anything that an appellate court can do in terms of making the jury or sending it back to a jury or overturning a conviction in today's law?
Yeah, the appellate court can say that a jury's conviction is unreasonable or a miscarriage of justice. And so this gives an appellate court, as well as based on an error of law made by the trial judge in explaining the law to the jury. But appellate courts do weigh the reasonableness of jury verdicts, although in Canada, they've been fairly deferential to the jury in saying the question isn't whether we think that the person was guilty reading the transcript. So we haven't even recognized lurking doubt as a ground for appeal. And of course, if jury nullification results in an acquittal, and some people have argued that that was the case in the Gerald Stanley case, the Crown can only appeal on the basis that the trial judge made a mistake in explaining the law to the jury. So in part because we're concerned about wrongful convictions, we do allow the appellate courts to weigh issues of whether the verdict is reasonable or a miscarriage of justice. But as I said, appellate courts will defer to the jury, which is, also difficult, I think, for the appellate courts because, all they have is the jury's bald verdict as opposed to its chain of reasoning.
Right. But it strikes me that jury nullification does happen in Canada. It seems to be very rare, but at the end of the day, it does seem to happen. So, why is it that courts are so guarded against even a discussion of that by defense counsel to the jury that, hey, listen, if you think this law is unfair or that the prosecution's case against my client is unfair, why is the trial judge expected to really try to hamper that conversation?
Yeah, well, I mean, I think especially in the charter era, there is a sense that, it's really up to the trial judge to ensure that everything is fair and that those arguments, whether they're that this is a fundamentally unfair prosecution or as in Morgenthaler, the law is unjust, really should be decided by the judge often beforehand, and that the jury has an expertise in determining facts and applying facts to the law, but it's really the judge who's the expert about the law.
So trying to keep the assigned roles maybe so the system operates efficiently and effectively.
Yeah, and also, I mean, jury nullification has a checkered history, and so the Supreme Court in the Morgenthaler case referred to the use of jury nullification in the American South, essentially to kind of allow violence against Black people, kind of a legalized form of lynching. So, I mean, it's important to note that jury nullification can go in different ways. And again, the difference is if the judge decides the law is unjust, the judge gives a reason, whereas the jury doesn't. So, I recognize that abortion in the Morgenthaler case, lots of people disagree, but I'd rather have the reasoned judgments from the Supreme Court, including some dissents, as opposed to an inarticulate verdict of not guilty from the jury.
Right. And that's certainly the criticisms with jury nullification is that it's all well and good if the majority of Canadians say, yeah, this is an unfair law, it's prejudicial or whatever, but then it could go the other way where you don't know if the jury is using prejudice or bias in another case to disregard the law. So it's definitely concerns. Now, in our case that we're following, Kent, there's been 2 jury trials so far. The first one was a lengthy trial. I think it was about 4 months, and the jury came back it was a hung jury. Can you explain to our listeners what that means, what that phrase means?
Yeah. It simply means that all 12 jurors don't agree on a verdict. So they don't agree on an acquittal. They don't agree on guilty. And usually, I don't know whether this was the case. Usually, the trial judge keeps sending them back and says, look, there's already been a trial. Witnesses have testified. Not only the expense, but also just frankly the trauma of going through these things. So judges don't allow juries to hang lightly, but at some point they accept that this jury is just not going to agree. And we don't know whether it's 6 for guilty, 6 for not guilty, or one person who is the holdout.
Right, because that type of breakdown is protected, I guess, by the same secrecy laws that we already discussed.
Exactly.
You mentioned earlier that you need all 12 jurors to come back with a unanimous verdict. I did see some articles or some other jurisdictions that look at a majority rule, and it's not like a 7-5 split. It's usually like 10-2 or 10-1 is kind of the threshold they're looking at.
Yep.
Do you think majority rule would be an okay system for juries? The reason I ask is because for our judges even, right, there's often splits at our appellate courts of some dissenting judges. So why does it have to be different for juries?
Yeah, no, I mean, that's a fair enough point. Although I do like the unanimous verdict juror system because I do think that empowers people on the jury who may have a different perspective. Although I do worry about the juror caves, perhaps because he or she wants to go home. But also, I think that, we're dealing with a criminal verdict that whether it's guilty, especially if it's guilty, but even if it's not guilty, has a lot of weight. And we're essentially asking citizens to exercise that power. So I think that, the power of a jury verdict when it comes in is you had 12 citizens who all agree. And I think if we even move to a 10 or 11 system, it would be a little bit murky. So, when appellate court judges disagree, they disagree on issues of law, which are often debatable. The jury is supposed to kind of find what the facts are, and they're supposed to determine it on the basis of proof beyond a reasonable doubt. So I think even if there's one person who says, look, looking at all of the evidence or lack of evidence in this case, I have a reasonable doubt, I think we should probably still respect that.
That's fair. So Peter Beckett, after he went through his first trial, they proceeded with a second jury trial. And just wondering if you can give us an idea of what differences, if any, there would be in selecting a jury in a second trial.
Well, I mean, you've already mentioned that the Crown's not going to have a third trial. I could certainly tell you that if there was a third trial, the way we select juries today would be very different than the way we would have selected it even in, 2018 or 2016. So in selecting both of the juries, Mr. Beckett would have had an unlimited right to challenge jurors for cause on the basis that they're not impartial, but he would have to convince the judge that there was a realistic possibility that some of the jurors might not be partial. And so generally that is going to involve issues of kind of pretrial publicity. Today, if there was a new jury trial, that would still exist. But what would no longer exist was the fact that he would have, if he was charged with first-degree murder, 20 peremptory challenges that basically says, I don't get a good feeling about this juror, and I don't want this person on my jury. So I don't know the details about jury selection. Generally, we don't know about that unless, as in the Stanley case, family members and the press cover it, and they often don't. So I don't know whether he exercised those peremptory challenges in his first trial that resulted in a hung jury, whether he did so in his second trial. But I do know that if there was a third trial, he would only have the challenge for cause. And many defense lawyers feel that is making the jury system much less fair, that they believe that there are lots of reasons that perhaps are not articulable, where you just feel like a juror, perhaps because the accused knows them or has an impression about them, you don't want that person on a jury. Of course, the peremptory challenges were abolished, and I actually supported that because they were used in the Gerald Stanley case to keep 5 visibly indigenous people off of the jury. So, that's so the real difference, I think, in jury selection would have been if there was a third trial. Now, at the second trial, because it's a retrial, I would have expected, although again, I don't know this to be the case, that there might have been questions on the challenge for cause about whether the jurors had heard about the case. And if they had heard about the case, had they formed an opinion about the case. But even then, in Canada, we don't allow either side to question jurors very closely because there's a sense that jurors are really being conscripted, and they're paid very little, and they're subject to trauma, especially in murder cases. We don't want, questions that would invade their privacy. So even if a question had been asked at the second trial, have you heard of the accused? Have you formed opinions? Most judges have a strong presumption that jurors will be able to follow their oath, which is to decide the case fairly and impartially only on the basis of the evidence heard in court and not on the basis of any preconceptions or public opinion that they were aware of before the trial started.
Okay. And I guess at the same time, defense could bring their application for a change of venue, I guess, if they felt there was enough prejudice or publicity around the case.
Yeah, although I have to say change of venue is a very Victorian era solution to pretrial publicity. It really is based on the idea that it's local gossip and local newspapers that produce prejudicial pretrial publicity.
Another outdated concept for today's times, social
Well,
media.
no, one of the things that I found when I was writing my book on the Gerald Stanley case is that, they didn't even ask the jurors whether they had participated in social media campaigns, because there were GoFundMe pages and petitions on both sides in support of Mr. Stanley and in support of Colton Bushy and his family. And I don't think we've really caught up to the social media age when it comes to evaluating whether jurors are going to be impartial.
So we could talk forever about the Gerald Stanley case in particular, because it's such a polarizing topic in general, but there's a lot of interesting facets of law involved. But just your thoughts, because Bill C-75, which came into effect after that case, there has been some criticisms that it was a bit of a knee-jerk reaction on the part of the government. But I did read your article, and generally you think it's a good development.
Yeah, no, I actually do. The UK has abolished peremptory challenges. So, to the extent that the jury is an inheritance from England, I think that works. And I was very moved by Justice Thurgood Marshall, who, of course, was the first Black justice on the US Supreme Court, who was also a proponent for abolishing peremptory challenges, as was Justice Murray Sinclair in his Manitoba Aboriginal Justice Inquiry. But I recognize, and of course, I was involved in the recent case before the Supreme Court arguing that it was constitutional. But I had a lot of friends on the other side who disagree with me passionately. So at least I hope that they're still friends.
Right. Well, like we discussed off air, it's a discussion and dialogue that we make advancements and improvements to our systems. So I am mindful of your time, and again, we could talk. There's so many other things that we could discuss, or that I would love to get your thoughts on. So maybe down the road we can do this again. But we really appreciate your time coming on the podcast, and your insights were great to have.
Well, thank you very much. I've enjoyed it, Trevor.